No, he wanted me to get up there and go on the record and talk about it right now, and I said I can't. There's not enough time. We need to get this done.
Okay, we're back on the record. Technical staff, are you ready to go? Okay. This is the April 25th, 2018 formal hearing of the Utah Board of Oil, Gas, and Mining. Our first agenda item is docket number 2018-002, cause number 210-06, in the matter of the State of Utah School and Institutional Trust Lands Administration and Enduring Resources 2 and Westar Exploration Company. At this time, we'll take the appearances of council.
Mr. Chairman, that matter has been continued.
Say that again for the record.
The SITLA matter has been continued for next month.
Okay.
Until June, I'm sorry.
Okay, my notes just said it was recorded, it was continued from the March hearing, and it's continued till June?
Yes, that's correct.
Okay. All right, that matter has been continued. We're on to agenda item number 2, docket number 2018-005, cause number 139-154, in the matter of Crescent Point Energy U.S. Corporation. I'll take appearances of counsel on this matter.
Brent Chicken, Fox Rothschild, LLP, on behalf of Crescent Point Energy U.S. Corp.
Okay, others?
Emma Whitaker, Utah Attorney General's Office, on behalf of the Division of Oil, Gas, and Mining.
Okay, others? Seeing none, we're to you then, Mr. Chicken.
Thank you, Chairman Gill. This matter is not going to directly affect Crescent Point's other similar overlapping spacing orders, but you're going to hear and see a lot of similar things before. The previous matters were the 139, 151 matter, which are kind of to the south and east a little bit of these lands, and the 131, 151 series of matters, which was the Randalet lands directly to the south. And so I think what you'll find today with our witnesses and our evidence is that you'll see many of the same concepts. The overlapping spacing request, we're going to be asking for maintenance of the existing 640-acre spacing. Those exist currently under Order 139-180 or 139-84 and 139-135 on the lands for today. And those have 640-acre spacing with 4-well density. And we're going to ask that be maintained. Then we're going to ask also for overlapping 640-acre spacing units for short lateral horizontals of 1 mile up to 1 mile in length, and 1,280-acre spacing units for 2-mile laterals or long lateral horizontals up to 2 miles in length. And similar setbacks of 330-foot heel and toe, 560-foot lease boundary. And in fact, that's really the only change that we would be seeking to the existing orders is we tighten those setbacks up a little bit. I believe they're currently 1,320 feet interwell and 660-foot boundary setbacks, and we just believe those are just too big. These are older orders from that have been around primarily for vertical development, and we think we have engineering and geology that allows for the smaller setbacks that we've seen in the two previously 139, 151, and 131, 151 orders. And again, Crescent Point continues to believe that this is the most protective way of drilling and still protecting correlative rights, preventing waste, and increasing and maximizing the resource recovery. Specifically on correlative rights, we believe that these spacing schemes do that for three key reasons. The first one is that no party is mathematically diluted, because each one of these separate spacing units that overlap one another is separately paid, accounted, and allocated. There is no mathematical dilution that anybody experiences in any given well. They own what they own in that well, and it won't change. These are also all-inclusive. Unlike other spacing schemes that this board has seen, this doesn't require people not to drill a certain type of well, or discourage or render uneconomic a certain type of well. And specifically, I mean vertical and directional wells. We've heard testimony in the past several months that vertical wells may, certain parties believe vertical wells to be waste, directional wells to be waste, and that you should only drill horizontal wells. Crescent Point doesn't necessarily believe that. They're not ready to jump into there. They believe there's a lot of value in vertical wells, and there's value in inclusivity, and making sure that everybody that is an owner has the right to go out there and either participate or drill the kind of wells that they want to drill. We can all find a way to get along, and we believe that overlapping spacing is the way to do that. And last but not least, we don't really run into any, we protect correlative rights because we don't have any weird effective date and timing issues. We would ask that these orders be, we ask all these orders are effective at when the board signs them. We don't have to wait for them to become effective till a well is drilled, or until production happens, or until this agreement is signed, or that or not. These things would become effective immediately, and that allows folks to plan, and when I say folks, I mean everybody, not just Crescent Point, but the BIA, the BLM, the state, the division. It allows everybody to plan for what's going to happen, because you know what it's going to be today. You don't have to wait for some time in the future when it's going to change to that.
And when you talk about the future, you're talking about the conversion tech approach?
Correct. Which most of those orders have an effective date when the long lateral horizontal is drilled, and depending on how that works, you may never drill one. There may be one drilled. You may not know what's going to happen in there. It may force, for example, if you're in a, that effective date becomes really important if you want to drill a new vertical or directional well inside of that 1,280 acres. Because if you get it done before that other one gets on production, you're going to be spaced on your 640 or your 80 or whatever. And if it's afterwards, you're now spaced on a 1,280, and you're sharing your production with maybe, in some cases, double or triple the amount of owners and acreage that you would before. And so I think that gives you a lot more. It gives those folks.
And so the industry term for this is overlapping?
Correct, for this type of spacing. And 139, 151, and 131, 151 were both the same exact type of spacing. So, and with that, I'll go ahead and call my first witness, unless the board has any other questions.
No, please. And then we'll accept exhibits at the end of the...
Sure. And would we like to swear all the witnesses in collectively?
Please, let's swear the witnesses.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you.
Let the record show that that was all of the Crescent Point witnesses.
Okay, thank you.
Okay, proceed.
So the first witness I'm going to call is Tom Abel. He's a landman for Crescent Point Energy, but I'll ask Tom to please give the board a brief rundown of your post-high school education and experience in petroleum land.
Sure. Thanks, Brent. To clarify, I'm a senior landman with Crescent Point Energy. And
all this time we thought you were managing land.
Prior to Crescent Point, I worked at Bill Barrett. I appeared in front of the board probably 5 or so years ago, so it's good to be back. And been in the petroleum land business for about 10 years, both in the field and in-house. And both in-house positions are with operators.
Okay. All right, thank you. With that, we will move on to our first exhibit. If I can, there we go. So this is Exhibit A, and this is going to be our general regional locator map. And if you could just discuss kind of the location of the land shown on here in relation to other key cities in northeast Utah.
Sure. So as you can see, the lands, some of them actually kind of straddle Highway 40 there, which puts you approximately 8 miles east of Roosevelt on the furthest east DSU, and then as you move west across the position, you get to Ballard and Roosevelt, and by the time you're up on the furthest west side of our spacing application lands, you're approximately 5.6 miles northwest of Roosevelt.
Do you cover the golf course?
No.
Okay.
I believe so.
Not yet. Sorry. Thank you. We'll move on to Exhibit B, which is another depiction of the cause outline, but specifically dealing with the request for agency action Crescent Point's filed. It's the notice and buffer zone in which we gave notice. Can you please describe for the board who notice was given to and what land area notice was given across?
Yep. So we of course notice those parties within the spacing DSUs themselves, as well as within a half-mile buffer around all of those DSUs, since we are requesting reduced setbacks to 560 laterally. And the owners that were noticed were all leased owners and unleased working interest owners as well. And the notice list was published in the newspaper and through the board via mail.
I just want to clarify, that was the request for agency action was published, correct?
Yes, correct.
Okay, thank you. And to Crescent Point's knowledge, have there been any protests or responses filed regarding its request for agency action in this matter?
No.
Okay, thank you. We'll move on to Exhibit C. This is our replacement Exhibit C, and I guess now is a good time to bring this up on...
I have signed the order.
The order to allow the replacement. Okay, I appreciate that, Chairman Gill. So this is the replacement. I know it's not totally conspicuous, but, oh, you can't see it on yours. Trust me, it says replacement above Exhibit C, right outside of the viewing area of this. This is the exhibit, and this is the exhibit that was attached to the motion that resulted in the chair's order. So, Tom, if you could please describe what the exhibit depicts and the ownership of the lands that Crescent Point is seeking to space today.
Yeah, so we just had some updated ownership is why we replaced this. We just wanted to make it as accurate as possible. So what you're seeing here is a mixture of federal ownership, fee ownership, some state ownership, and some tribal ownership as well, along with some allotted. So we have a little bit of everything across the position here as far as ownership entities go. And Crescent Point does own substantial leasehold across these DSUs as well. So it looks like we have every type of ownership throughout our lands here.
Indeed. And just as a clarification, when we talk about existing wells on the key, that means not only drilled wells but also approved and permitted but not drilled wells, correct?
Correct.
Okay. I just wanted to make clear, some of the little green dots you're seeing on there are not actually drilled yet, but they are approved, and they have APDs. We'll move on to Exhibit D, which is discussing, this is the current spacing scheme that's there for vertical and directional wells. If you could just discuss that and discuss any changes that we're seeking to make in terms of the setbacks.
Yep, so as Brent mentioned in his opening statements, we really are maintaining the two existing orders here, 139, 135, and 139.84 across these lands for vertical and directional wells. So those will continue to be allocated on a 640-acre basis. The only difference being the interwell and boundary setbacks. So we are requesting a reduction of the interwell setbacks from the 1320 currently existing under those two orders to 330 interwell setback. And then the 660 lease boundary setback that currently exists, we're asking to reduce that to 560 laterally on these stand-up DSUs.
And then these existing 640s with 4-well vertical directional well density, those are going to have all production from all vertical wells in each 640 allocated to that 640, just as under the existing orders, correct?
Yes.
So we'll move on to Exhibit E, which is going to show the first set of overlapping spacing, the 640-acre spacing for the short laterals. And if you could, same level of description as you had with the previous slide.
Sure. So these will overlap the vertical and directional 640 DSUs. So same lands, and here we have 12 640 DSUs for short lateral horizontal wells. And we're requesting up to 12 short length lateral wells within each of these 640-acre DSUs. Currently there's one short length horizontal well allowed per 640 under the current orders, just as a note.
Is that under the current orders or the current rules?
Current rules.
Correct.
Yes, the current rules. So again, it won't impact production from either existing or future vertical or directional wells within the 640-acre units.
And so production from any of those short lateral horizontal wells in those 640-acre spacing units would be allocated across that 640 as well, correct?
Yes.
And we'll move on to our last depiction here, really, of the final overlapping spacing units that we're requesting today. And these are 1,280 acres for long lateral horizontal wells. And if you can, again, just provide the board with a little bit of information in terms of the 2-mile laterals and how we're going to space these and allocate them.
Yep, so these overlap the same 640s that we just discussed, except they're on a 1,280 acre basis. So there's only 6 units here instead of 12 640 acre units. You combine those and you get 6 1,280 units. And we're requesting up to 12 long length horizontal wells within each one of these 1,280 acre drilling and spacing units. And production from a long length horizontal well will be allocated on a 1,280 acre basis go forward.
And so I guess now is a good time to just kind of bring this up so that there's a little bit extra information in the record. And I touched upon it in my opening, but what are some of the reasons that Crescent Point feels that this spacing scheme, the overlapping spacing scheme, is going to protect the correlative rights of all parties and all owners in these lands?
Well, I think the fact that we're maintaining the 640 acre spacing that exists currently with vertical, directional, and short length laterals, I think that in and of itself goes a long way to protect correlative rights, especially for those parties that do want to continue to develop on a vertical or directional basis. We're not going to dilute them into a 1,280 acre unit, even if we drill a long length lateral well, although that production will be allocated on a 1,280 acre basis. the parties in each one of those sections on a go-forward basis, their rights will be protected by allowing them to operate under the existing 640-acre spacing.
So I won't have any other further questions other than to ask. Were Exhibits A through F all prepared by you or under your direction, supervision, and control?
Yes.
And do you believe that the relief requested in Crescent Point's request for agency action will protect correlative rights, minimize waste, and afford maximum recovery of the resource?
Yes.
I have no further questions for this witness.
Vision.
I do have one question. So the request states that future long lateral horizontal and short lateral horizontal wells may be located outside the drilling unit, subject to the acquisition of proper surface and subsurface estate authorizations. It might be helpful to the board to explain what you mean by proper authorizations, and this is a question for you, Mr. Abel, or Mr. Chicken may be able to answer.
I'm happy to take a crack at it.
Either one.
Yeah, so when we're talking about off DSU surface locations, of course we will obtain surface use agreement with the surface owner, and then when you discuss the other agreements, we would, with that surface owner, acquire a subsurface easement, as well as permission from lessees and/or unleased mineral owners in that tract.
Okay, thank you.
And I just want to clarify that last little bit. There's always been a question when you're getting the subsurface easement from the party with the right to develop the minerals, whether obviously usually the exclusive right to develop those minerals is passed through the lease to the lessee, but that is a term-limited right by nature. When there's no production, the lease dies, and therefore everything that was created out of it, overriding royalties, other things like that, die as well. And so that's one of the difficult risk kind of questions for an operator is, do I just go get my subsurface easement from Axia or Newfield or Crescent Point, who's the lessee on that off-lease location, or do I also ask for that permission from the mineral owner? Because if the lease expires and I've only gotten permission from an operator, so does my subsurface easement. So we generally try and get both if we can, if they will agree to it. Sometimes it's difficult to do that. We will get definitely one or the other for sure, and we'll try for both where we can. But so just a little extra.
Question, Mr. Chicken, isn't it usually the case where you only have to get one mineral owner or lessee under that to get that easement?
I think that's correct. In other words, if you've got undivided ownership underneath there, and you've got, two parties own an interest in a lease, for example, I think the answer is yes. You can get permission from one of those parties because it stems from. It's a little different than tenancy in common, right? Like two tenants in common, you have to get permission from both of them. And even though two parties owning undivided interest in a lease could be seen as tenants in common, the point is that they own undivided in a lease. And just like either one of them could seek to space or pool or drill a well or file an APD without the permission of the other, either one of them can also give that subsurface easement. And you also have to recognize, too, the mineral subsurface, the subsurface easements are an extraordinary level of protection. And the reason for that is because speaking as a litigator, from a damages perspective, if you drill through somebody's subsurface or minerals and you do not perforate, obviously, you're not perforating, you're just drilling a tube through their stuff, they're going to have a hard time proving damages. If it's a surface owner, their damages are going to be related to your wellbore destroying the ability of the land to maybe store natural gas in a pore space or something. But to prove that, you got to prove that it could store natural gas before I drilled my hole. And most people aren't able to prove that. And the same thing with mineral owners. They, just drilling through their lands, they would have to show that your wellbore somehow screwed up their well or their plans. And it's really difficult to do that. And most times a wellbore just, passing through is not going to create that problem. So I think in either one of those cases, you want to get these protections, but they are extraordinary protections because the risk that there's going to be significant damages is actually fairly low.
Thank you.
No further questions for this witness.
Well, you sure brought up a big one. Yeah, I mean, the questions of do you need to just get the surface owner? If there were no minerals, would you just, I'm assuming there's no mineral value whatsoever on the offsite, under the offsite location, or the right-of-way.
To the party that's drilling, you mean?
The party that was drilling it, just as a legal question, couldn't you just get that right for that easement from just the surface owner?
You can, and the company can take a business risk, but as an attorney, I would advise my clients that, there can be situations where you are drilling through somebody else's minerals and you are not perforating, but your wellbore creates a subsurface issue that screws up their frac or makes their, makes their well more difficult to drill and they have to twin it or something. But again, those are few and far between, Chairman Gill. I think those are very few and far between. And again, the measure of damages in these cases is what that operator had before you drilled your well and what it has after you've drilled your well. And in most cases, the party can't set up what they had before because nobody's just running around drilling test wells to figure out what might happen if somebody else drills through me to get to somewhere else. And anecdotally, I'll add that your answer would be correct based on a recent Texas Supreme Court decision where they did not get mineral owner permission to drill through. They didn't perforate. They only got surface owner permission, and the Texas Supreme Court held that that was okay. So I don't believe that would be the law in Utah or any of the other Rocky Mountain states. I believe it would be a trespass is touching somebody else's land with your body or an instrumentality. And a wellbore, a drill bit is an instrumentality that you can use to trespass with. And so that Texas case in Colorado or Utah or Wyoming would be mineral trespass. I don't know, but again, you can make the claim, but can you prove your damages? Because if you can't prove your damages, I don't care how good your claim is, you lose.
That's right. Okay. We're back to you for your next witness. Or for...
Wait. I have another question.
I beg your pardon. Board member questions of this witness.
Would you describe how you did notice to lease owners and what you published in the newspaper?
Yeah, we didn't.
No. I'm sorry, just a clarification. We don't do the publication. The division does the publication.
Okay.
He was just noting that. That's all.
How do you give notice to lease owners?
We do title research to come up with our notice list of owners that we send the notice to, and then Mr. Chicken and his firm prepare the notice of the agency action and actually physically certified mail to each one of these owners our request for agency action.
What do you do to find non-locatable owners?
What
due diligence do you do to find non-locatable owners?
We research what's of record, and we rely mostly on the county records for locating owners.
What percent of the sections that we're looking at today have what percent of land is non-locatable as far as ownership, mineral ownership? In other words, Did you find 100% of mineral owners, 97% of the land, 95% of the land?
And I think I can answer this because we actually are the ones that sent out the notice. We sent this notice to 1,406 people, which actually includes royalty owners and mineral owners, because the problem is if you want to take those mineral owners and separate them out, you run the risk that you're also going to separate out a working interest owner that's entitled to notice, so we leave them all in. So we kind of grossly over-noticed this matter, as Crescent Point habitually does with all of its matters, because we'd rather spend more money and send it to more people and then try and save that little bit of money, and then somebody that's supposed to get it doesn't. I can tell you that out of those 1,406 names, I think it was right around 20 people were unlocatable. So we're probably less than 1% of the total number of people that were sent to were unlocatable. And those folks, the location efforts, you know, the statute requires us to provide that, or to send notice to the last known, I should say the statute and the rules, to the last known record address as shown in the county records or in the records of the division and the board. And so we look in those two places for those addresses. But then I think another piece of due diligence that Crescent Point engages in is Crescent Point will also cross-reference its lists with lists from other operators that have shared their lists with us, and so sometimes, you know, we'll end up with, you know, bits and pieces of a list from Axia or from Newfield or from EP Energy or something, and so that's really the pot that we draw from, is every address of record, every address that the board or the division has, and every address that we can get or that will be disclosed to us by other operators. And then in terms of you know, unlocatable, there are, you know, basic efforts made to try and connect the dots if you can internally, but I can tell you that you know, because the statute, because notice is certified or is satisfied under the statute by sending to that last known address, those efforts aren't Herculean. There's, you know, we're not out hiring private investigators and spending, you know, lots and lots of man hours trying to find one individual, particularly given the fact that most of those times these people are not folks that own substantial working interests. So for example, I can tell you that there are no working interest owners that were unlocatable. There were mineral and royalty owners who technically weren't entitled to notice that were unlocatable, and we've tried to find those people as well. But if you can't find them, the law in Utah doesn't require us to expend lots of time and energy trying to find individuals who own small amounts. The key here is anybody with the right to drill a well or to come and space or pool these lands is entitled to notice, and we believe that those people have gotten notice.
Thank you.
Thank you. Anyone else? Okay, back to you, Mr. Chicken, for your next witness.
Thank you.
We're going to take, let's see, where are we now?
Noon.
What time will lunch be here? Noon? How much longer do you think you have? If you're going to go past, I'm wondering if this would be a good time to break. We're going to have a working lunch and then come back after lunch and motor through.
Board's prerogative, whatever the board wants to do.
No, I'm just asking, would that work for you? If we do want to be done so that if there is a flight deadline.
I think we're all on the 3 o'clock flight, so we're good.
So we could.
You can take your break.
I don't think we're going to take 2 more hours. So if we got back at 1, took another hour.
I think another hour would be more than sufficient to finish up.
Okay, board members, is that something that you're comfortable with? Why don't we do that then? We're going to take a break and come back at 1 o'clock or as close there after as we get through with our working lunch. And with that, we appreciate your time, and we'll see you then. Thank you for the presentation and for the discussion.
Thank you.
and currently working in the Uinta Basin.
Okay.
We need your address.
Oh, I work at 555 17th Street in Denver, Colorado.
Thank you for that, Mr. Chair. Mr. Rogers' resume is part of the exhibits. I believe it's Exhibit R, has all of the witness resumes put in there. And based on his resume and his stated educational and petroleum geology experience, I'd like to ask that Mr. Rogers' testimony today be accepted as expert testimony for purposes of this cause.
Vision?
We do have one request. Mr. Rogers, it looks like you're new to Utah, and it may be helpful to just kind of explain how your experience elsewhere with geology relates to that geology of the Uinta Basin.
Sure. I've been working in unconventional horizontal resource plays since about 2007. I've had extensive research and publications in the Rocky Mountain region. I've worked adjacent basin, the Peanuts Basin, for over 5 years. Similar geology, and go through this exhibits today and share that as well.
Okay, great, thank you.
Board members, any objections? He will so be admitted for the purposes of geology.
Thank you, Mr. Chair. With that, we'll move on to our first geology exhibit, which is Exhibit G. Mr. Rogers, if you could please just discuss this exhibit in terms of where the lands that Crescent Point is seeking spacing today, and you know, the handful of existing wells, or I should say actually drilled and producing wells on those lands, and the other items that are in this exhibit, please.
As you can see here on Exhibit G, the red boxes, those rectangles, they outline the application lands. You also see green producing wells, and you see the red arrows, which represent Crescent Point's horizontal wells in Randallette and Rocky Point.
And so, and I know we're going to get into this in a second, but so in a lot of ways, the geology is also tied into the geology that we see to the south of these lands, in the Randallette and the ridge areas there to the east, correct, or to the west? Sorry, correct?
Yeah, that's correct. You can see in those red rectangles there are no horizontal wells, but you can see the prevalence of the vertical wells around it, and you can see the horizontal wells to the south by other operators in Newfield and Axia and Crescent Point in red.
Thank you. Exhibit H, this is your type log for the Brotherson 1-11-B4 well. If you can please describe for the board what this log is telling us about the subsurface geology, and specifically the LGR, Lower Green River, and Wasatch that we are seeking to space today.
So as you see here on Exhibit H, this is a deep Brotherson well drilled all the way down to the Mesa Verde. These are the application lands from the Green River down to the top of Mesa Verde. You see the Wasatch, the TGR3, and the Mahogany Bench outlined on the formation tops.
Okay. Move on to the next exhibit, which is Exhibit I, which is going to show our lands for our, well, the zoomed out view of the lands for the cross section. Could you please describe your A and A prime wells, and how that was used for the geology for the subject lands today?
Sure. As you see on this zoomed out regional map, again you see the application lands outlined in red. And in the black line, A to A prime will be the cross section we show in the following Exhibit J. And as you'll be able to see, the green outlines the oil and gas pools around producing vertical well bores. And you can also see the vertical and horizontal wells again.
And just folding right into Exhibit J, which is the individual wells that were shown. This is the actual type logs from the cross sections of A to A prime. And if you could describe what those different wells are showing in terms of trends for the not only the subject lands but also the benches within the lower Green River and Wasatch formations.
Sure, this is the previously mentioned cross section. Going from the west to the east across application lands, you see the continuous nature of the geologic formations and the formation picks we've shown from the Green River down through the Wasatch, showing gamma ray and resistivity on the well tracks, gamma ray on the left and resistivity on the right.
Okay. We'll move on to, we have a final geology exhibit, and this is Exhibit K, which is our estimated ultimate recovery map showing the subject lands. If you could describe how those EUR bubbles relate to our specific lands and the surrounding vertical and directional wells.
Sure, these similar map you saw before with the application lands in red, showing the green EUR bubbles are the verticals, and that's predicted decline curve to our engineers estimate ultimate recoverable, and then the orange is the estimate ultimate recoverable of the horizontal wells with the bubble on the bottom hole location. Very common practice is to post the bottom hole location so that wells drilled from the same pad don't overlap each other. And as you can see, the recoverables from those horizontal wells are very large, and we deem to be potentially larger than some of the vertical wells in the area.
And as we look at this exhibit, I noticed there's, on the western side, there's far more EUR bubbles going on in some of those areas. Is part of the relief requested today by Crescent Point directed at being able to drill additional horizontal wells in these subject lands and be able to kind of flush out a little bit more the information and give them the flexibility to learn more about those lands?
Yeah, as we go forward, be the first horizontal wells in these application lands, we look forward to these EURs as we test these wells to be similar results.
And were exhibits G through K prepared by you or under your direction, supervision, and control?
That's correct. I prepared these exhibits.
Okay. And do you believe that the relief that is requested in Crescent Point's RA is going to protect correlative rights, minimize waste, and maximize resource recovery?
Yes, that's the purpose.
I have no further questions.
Vision?
No questions for this witness.
Board members? Okay.
Your tract in 2 South, 2 West is deeper and more basinward than any horizontal wells drilled so far. Could you give us an idea what you see there that you want to step out and do this, or what's your rationale for this tract that's a little bit anomalous as far as previous drilling goes?
Hey, let me make sure we're clear on you. Where are we on this map that you're talking about?
2 South, 2 West. It's
Okay.
the most northwesterly
All
of
right.
their
Board members, you're all there with that?
Yeah, I'd be happy to answer that question, Mr. Kendall. The lands up there further to the north, we're expecting potentially higher pressure and higher producibility from these horizontal wellbores. As we move north into the ultimate Bluebell field, the cumulative oil recovery has been very large in those vertical wells. As you see that the cumulative oil, the EURs on those wells potentially haven't depleted that section. So we think that there is remaining horizontal potential in that further north and potentially higher pressures, so to increase well producibility. However, that is a test area as we step north. It may or may not prove what we'd like to do, so we need to go in there and test a horizontal well to see what the recovery was. And that's also an area where we have mineral interests, so we'd like to recover the minerals underneath our ownership.
Thank you.
Other questions? Go ahead.
What kind of interference are you anticipating with the existing vertical wells from the horizontal wells?
As we move into new areas, that's something that we are going to test. Currently, we've undergone drilling experiments down in Randolette where we've drilled between existing producing vertical well bores, and our engineers can comment more on that, but we haven't seen significant changes to warrant not drilling horizontal wells.
Okay, thank you very much. Call your next witness.
My next witness for engineering matters will be Keith Shetney. Mr. Shetney, if you could state your full name, your current position and title for the record.
Keith Shetney, development engineer for the Uinta Basin for Crescent Point Energy.
And you've appeared before this board before and given expert testimony on petroleum engineering matters, correct?
That's correct.
Just as a and your resume is also attached to the materials in this matter as in Exhibit R, correct?
Correct.
And so just to give the board a little bit of a refresher on, yeah, you have to talk, a little refresher on your education and background. If you could just briefly touch on that for them, please.
Sure. I graduated from UC Santa Barbara in 2010 with a bachelor's degree in mechanical engineering. I worked for Weatherford Laboratories in Golden, working various basins, including the Uinta Basin as a field engineer, doing core work from 2010 to 2013. From 2013 to 2016, I worked at Crescent Point Energy as a development engineer, working on laterals and unconventionals in the Bakken. And then from 2016 forward, I've been working the Uinta Basin as a development engineer, and currently working that.
Okay. Based on Mr. Shetney's testimony just now, his resume, and his former qualification as a witness, I'd like to ask that he be again qualified as a witness in petroleum engineering for this matter.
No objection.
Board members, he is so admitted as a petroleum engineer.
Thank you, Mr. Chair. With that, we will move right into Exhibit L, which is a very similar EUR map, but a little bit more zoomed in than the prior exhibit you saw. And it is chock full of information that I will ask Mr. Shetney to please describe to the board.
Sure. So you're looking at a zoomed-in EUR map, similar to the one that Nate just showed you. The cause outline there is in red, the 6 1280 stand-up units to the north. Again, the bubbles indicate estimated ultimate recovery, and those are from actuals and declines. And they're colored by vertical and horizontal. So again, the verticals are green and the horizontals are orange. What we're also calling out there is all the wells that Crescent Point has drilled. So we're pushing over 60 horizontals currently. Those are the stats at the time, and you can kind of see how each of the formations stack out in terms of how many we've drilled, and they're all colored accordingly. So the green arrows represent Castle Peak. Those are the most numerous, and then the red arrows represent Wasatch horizontals, and there's a lot of other colors for other formations. Some other things to note is we've done over 7 microseismic jobs across Randolette and Rocky Point that gives us some confidence in these cause outline lands. We have a pretty large seismic project across Randolette as well. And again, we've drilled 60 horizontal wells out here, and we have 3 rigs running. So lots of data and lots of exciting stuff for this cause outline to the north.
Correct. And just so that the board is aware of it, your request for agency action in this matter, if approved, will require Crescent Point to come back to the board and provide annual reporting on its results in this matter, just like Crescent Point has that. Well, any operator that drills on those lands would have that obligation, but Crescent Point in specific has that obligation in the Randolette and the ridge areas as well, correct?
Correct.
We'll move on with that to Exhibit M. This is the Ute Tribal 423-3 1 WH1 well, and if you could please describe this production curve and paying specific attention to describing for the board some of the abbreviations over here on the right-hand side legend.
Sure. So this example here is kind of tying into our estimated ultimate recoveries and our oil in place, as well as our recovery factors on the coming slides. But what you're looking at here is a rate time plot, so rate on the y-axis and time on the x-axis of the Ute Tribal 423 31WH1. This is a well in our Rocky Point acreage in 31W. It's a 1 mile Wasatch horizontal with an estimated EUR of 520,000 barrels. The colors on the chart there, the green with the red dots indicates actual production from the well itself. The red line represents the gas rate, and the blue line represents the water rate. So you can kind of see all three streams there, as well as our fitted curve in the bold green line, and that's the line that gives us that 520,000 barrel EUR. If you're looking on the right-hand side there are a few things to point out there. There's a lot of different numbers you'll see there. The ones importantly to point out are the B. That's the formation, or that's the shape factor of that curve we fitted, and that's a 0.58, so relatively conservative for unconventionals.
Now, I was going to ask you about that. This doesn't seem anywhere near as steep as the typical decline curves that we've been seeing.
So
could you just comment on that a little bit, and then?
Sure. Yeah. So the that B factor is not necessarily the decline factor. It's the shape or the bend of that curve. So the higher that number, the more bend in the curve there is, and generally the higher you are. The DI there is your decline or initial rate. That is the rate at the time where that line stops having actual. So it's at 15% decline there. If you were to bring that back to the initial decline, you're looking at 90% decline. So that's more in line kind of with what you'd normally see. So that 15% doesn't represent the initial decline. So I would say that generally this decline is in line with most industry declines.
Thank you for letting me interrupt.
No problem. There are a few other things in there, but mostly to note just kind of those decline parameters, that 613 QI, that's your initial rate. All these factors go into our type well, which we'll show on the coming slides.
Okay. Let's just go to oil and
Did that last exhibit show the barrels per day?
Yes, so the y-axis there is barrels per day on a log scale. So if you're looking at those initial rates, this well in particular had rates nearing 2,000 barrels a day for the first month on average.
We're seeing between 1,000 to 2,000 is typical.
Yep.
Is that in line with that? Is that the same thing you're seeing?
Absolutely, that is typical. It also depends on the operator. Certain operators tend to bring their wells on slower. So not reaching 3,000, 2,000 barrels a day, but maybe doing 1,000 barrels a day for months on end. So certain operators have a different initial flowback strategy, which would be part of the reason why you may see some of those variances in initial flow rates.
So we'll move on to Exhibit N, which is your really recovery factor and oil in place calculation. If you could just describe that in relation to the state 119B1 log that's to the left there, as well as identify some of those abbreviations in the calculation key there.
Sure. So these oil in place, or OOIP, stands for original oil in place. These are calculated off our type log here, the state 119B1, and we're using a section from the TGR3 down to the base of the Wasatch for these calculations. So if you're looking at the right-hand side there on the table, kind of walk through each one of these variables that goes into calculating the original oil in place. So area is A, that's 640 acres, so that's just one section. The height is our net pay, and that's 334 feet. Porosity is 9% on average. SW stands for water saturation, that's roughly 53%. B sub O is your formation volume factor, and that's 1.18 barrels per barrel. And then all of those factors calculate to our original oil in place across that section from the TGR3 to the base of the Wasatch, which totals up to roughly 62 million barrels of oil in place. So kind of going back to that single short lateral that I had shown in the previous slide where we had calculated roughly 520,000 barrels of recoverable oil. If you multiply that times 12 wells a section, which is what we're talking about in this order here, you get roughly 6.2 million barrels of oil recoverable from those 12 horizontals. So if you take that number and you divide it by original oil in place of roughly 62 million barrels of oil in place, we get a full density recovery factor on horizontals nearing 10%, and I would say that's conservative for horizontal plays generally across the Rockies and across the U.S. You look at somewhere between 10 to 15% recovery factor on average for these unconventional horizontals.
Just so my math is correct, if you were to take the recovery factor, 10% times the original oil in place, it gives you about 6.2 million barrels times today's price, West Texas Intermediate of around 70. Is my math right? That's about $434 million?
Yeah, that's pre-royalty, pre-tax, pre-OPEX, pre-differentials, yes.
And yeah, certainly pre-differential. And is that per well that we're looking at, or is that for the 12 wells?
That's the combined recovery of all 12 wells.
Thank you.
That would be on a 640, Mr. Chairman. That's per 640.
Trying to get my head around that.
Well, it gets even worse when you do the 1280, and you don't lose the production over the lease line.
$860 million gross revenue from a 1280.
Maybe more, because you're not losing. The 640's got to stop at the setback. The 1280 goes right over it, so you get another 50, 70 feet, maybe 100 feet or more, actually more than that, of productive wellbore when you do the 1280. So,
okay. But my math for the 12 is in
Correct.
line with your.
Yep.
Okay. $1 billion per fishing unit.
So we'll move on to Exhibit O, which is our setback illustration. And I think in here we're going to talk about not only the setbacks we're requesting, and also discuss a little bit how the minor changes we're making to the existing orders and those setbacks, as well as kind of follow up on the earlier questions regarding the communication between horizontal and vertical wells as well from an engineering standpoint. So if you could go through that, that would be great. Thank you.
Sure. So what you're looking at here is a kind of a diagram or an illustration of potential setbacks. So the setbacks we're requesting this order are 560s laterally east-west and 330s north-south. I believe the existing ones are 660 laterally. And some of the reasons kind of showing our rationale for the 560 setback are taking a look at our fracture parameters. So these are things we've calculated via those 7 microseismic jobs we've done on a handful of different horizontal wells in Randelette and Rocky Point directly south. What we found is generally the dominant azimuth is 61 degrees west of north, which is kind of shown there in that diagram. Then also our fracture half length, which is generally 290 feet. So that's where that number comes from there. So if you're looking at that diagram there, the red stick represents the wellbore, and the hard or bolded black lines represent the edges of the section. So what you'll notice there is that our fracture half lengths are, reaching even at the toe or the heel of that well. There's still 307 feet of, undrained or untouched reservoir that would give us enough confidence to say that these minimized setbacks still protect correlative rights and also allow us to drain more effectively the section itself. Another thing maybe to talk to is what Brent was talking about, horizontal and vertical well interference. That is, like Nate had referred to, it is a concern for us. It's something we plan to test as we move north, especially with some of these offsetting verticals. Crescent Point has drilled 2 short horizontals directly through an 8-well, or there's 8 wells in each one of the sections in Randolette, and we've drilled directly through those. So drilling
verticals, correct?
Verticals, sorry, yeah. Drilling horizontals, roughly 300 feet between existing vertical wellbores. And what we found is somewhat of a mixed bag of results. So some of these wells, they'll initially get hit with our frac, and they will take a lot of the frac load water and may negatively affect the well in the front end, and then it'll come back and it actually produces more. We found that some wells, they actually get an increase in production for whatever reason. So on average, I would say that with the data that we have from our 2 horizontal tests in Randolette, we find that on average it's a mixed bag, and I would say that we don't have enough evidence in either direction to say that we're negatively affecting our verticals. And if anything, I think we're still getting incremental reserves out of the ground, and generally not destroying what verticals do exist there.
And the specific subject lands for this RAA, do you believe that they're a particularly fertile ground for those future tests, given that currently there's 640-acre spacing with 4 vertical well density? We're maintaining that and allowing the horizontals in there with no setbacks between the horizontals and the verticals, that's a good place to test this theory because everybody owns the same, correct?
Absolutely, yeah. So we're not diluting interest on that 640. So you're still drilling these wells potentially closer than we normally would, not that 330 setback, but this is a great place to test it as, like you said, we have a 640 and none of it's being diluted, so everyone's still sharing the same minerals that they would have previously.
In other words, they share the same in the vertical and the short lateral horizontal, so there's no potential for dilution, correct?
That's correct.
We'll move on.
But that would not be the case on the 1280s.
No, and our request has a 330-foot setback from between any 2-mile lateral and a 1-mile lateral, or 2-mile lateral and a vertical or directional. The only place where there's no setbacks is where the verticals, directionals, and short laterals are all on a 640, so everybody owns the same in all of those wells, which makes it a particularly good place to go drill in close to stuff, because it doesn't really matter. Even if you screwed something up, everybody still makes the same, they still have their same interest.
Thank you.
We'll move on to Exhibit P. If you could please describe the 2 types of liners that Crescent Point employs in the Uinta Basin.
Sure. So these are 2 examples of 2 different completion methodologies and liners. There's the cemented liner on the left and the open hole swell packer diagram on the right. What you'll see in both is kind of those hard lines calling out our 330 setbacks. And kind of the point here to show is that not only do we have our productive wellbore set within these setbacks, but we've also got 3 layers of safety. We've got our surface casing, our intermediate casing through that 330 setback, and then we have our liners. So generally right now, Crescent Point's employing the cemented liner technique, but we have trialed an open hole swell packer. But just kind of speaking to the safety aspects of these liners, as well as what we're doing to protect correlative rights.
Okay. And we'll go to Exhibit Q, which is the last engineering exhibit, and this one is your economic summary. If you could please describe first the assumptions on which the calculations were based, and then kind of go over the rate of return and the return on investment and the time for payout and the other things depicted. Sure.
So the assumptions we've used are a March 1st start date, so all calculations are starting March 1st going forward. We assume 18.75% royalty on average. We're using fee severance taxes as opposed to tribal here. And our cycle times are 75 days, so cycle times for us represent the day we start spending money on the well, and that's generally when we spud the well all the way to the first day of production. So on average, we're in that 75-day range for drilling, completion, facility build, and first production. Our pricing is, at the time, was $55 per barrel WTI, not escalating over time, and roughly $250 per MCF with no escalation as well, so a flat price deck. Some of the gas assumptions we've used are an 800 SCF per barrel GOR, that stands for gas oil ratio, and 60 barrels per million NGL ratio, so that's the yield of the liquids that come out of our gas stream. And we've also assumed a 50% surface loss, and that's generally attributed to pipeline loss, compression, and stripping out NGLs in our gas stream. And then we've also assumed an 88% differential, and again, that's flat go forward. So those are the assumptions we used on the table above. Kind of walking through that table up there, we've broken out into a 1 mile and a 2 mile case. The capital on a 1 mile well for something with the frac similar to what we've employed on that 423 type log that I had shown, we're looking at roughly a $7 to $8 million AFE, so that's the range there. On a 2 mile well, $11 to $12 million of capital per long lateral horizontal, and then the EURs associated with each. So the 1 mile well, again going back to that 423 type log of 520,000 barrels. And then for the 2 miler, we scaled that up and just multiplied it times 2. Moving further to the right, there's our before tax net present value discounted 10%, and that's in thousands of dollars. So a 1 mile well drilled at $7 million has a roughly $7.3 million NPV to Crescent Point, and that's on a gross level. And then walking further down the row, there's the rate of return in percent, the ROI, or return on investment, and then the payout in years on the far right-hand side. So just kind of representations of what we think the economics could look like in some of these units that we've kind of gone over.
You got a plum job with those numbers.
I was actually thinking that. Just looking at them close, I'm like, I'd put some money in it.
Hey, explain a BTN. I know PV10, but BTN. Explain. So if you have a $7 million well, you're going to get 14,307 back, and of which 7 is clear. Is that what you're?
Yeah, that's correct. So that's when you speak before tax and after tax. Generally, a lot of oil and gas companies will speak before tax, and that doesn't mean that you're not paying tax. That represents paying your royalties, paying your severance taxes, all your state taxes. What it doesn't account for is corporate taxes. So generally, that's why we speak in before tax numbers. That's not a corporate number. But you are right. So what that's essentially saying is you will have roughly $14 million of revenue, 7 of which will pay back your initial investment, and you'll make an additional $7 million on that $7 million of capital you deployed.
How do you get this clients, Mr. Chicken? Just lucky, I guess.
I don't really have I'm the lucky one to have clients such as this. So, as far as I'm concerned.
Oh, man. Okay. Sorry to interrupt you.
No worries. So, Mr. Shetney, all exhibits L through Q were prepared by you or under your supervision, direction, and control?
That's correct.
And is it your opinion that the RIA submitted by Crescent Point in this matter will protect correlative rights, minimize waste, and afford maximum recovery of the resource?
I do.
Okay. I have no further questions for Mr. Shetney.
Vision?
With the board's leave, Dustin Doucette would like to ask a few questions.
Please proceed.
So if you could turn to Exhibit N as in Nancy. So on here you have listed your ER from your previous decline curve, your previous exhibit, which was done on Wasatch Formation, correct?
That's correct.
So out of the spaced interval, do you have any idea? I'm assuming it's going to be based off of, how much they flow back and stuff. But what formations or zones are you going to be targeting in that interval?
Sure. So as you move north, the geology changes somewhat. Nate knows better than I do, but generally what we find is that a lot of the Green River targets that we target in Randelette and Rocky Point, such as the Castle Peak and some zones in the Uteland Butte, disappear, turn into something different. We're still working through mapping those zones, but the biggest and first target that we would go after would be the Wasatch. Offset operators have done a great job delineating the Wasatch, and that'll help us develop these lands as well. But I would assume that we would trial one in the Wasatch, one in some unknown or TBD zone in the Green River, and maybe a deeper Wasatch test in some of these.
Okay, so, and I think you'd mentioned the Wasatch here will be overpressured. Is that in all of the subject lands? And
that's correct. As you move north into the South Altamont acres towards Bluebell and some of the older vertical fields, the pressure gradient drastically increases, which is why some of the EURs we've been seeing from offset operators are so great. So it's something we're excited about.
So as far as the Wasatch is concerned, the 520 is a pretty reasonable estimate of what you think you'll get, but I guess the question is, some of the others are kind of unknown as far as Green River targets.
Yeah, they are somewhat of an unknown. Like I said, area offset operators, particularly ones in South Altamont, have delineated other zones other than the Wasatch, the Uteland Butte being one of them. We don't know exactly how far they extend, but some of the EURs in the Uteland Butte have matched Wasatch EURs, so I guess it's more of a question of how far do these extend, but you're correct. In some of these, we're not exactly sure, but generally the Wasatch is our first target.
Okay. If you could turn to Exhibit O. And kind of the same question on this. You said this was based off of microseismic or generative. I guess maybe that's one question. You'd mentioned microseismic getting some of the data. Is that all the data that you use to generate these setbacks? Or?
Yeah, so we have. We don't have a lot of data on infilled horizontals in South Altamont, as the ones that do exist up there are single well in-unit tests, but we do have actual production results from our wells in Randelette and Rocky Point on 4 wells per section density with these exact same setbacks. And production results back up the fact that our microseismic is showing this is the correct drainage area. So we've got both microseismic to make these numbers, but also we have production results to kind of back up that spacing is correct.
So is the microseismic based off of Wasatch frac data, or is it entire spaced interval data?
It's a mix of both. So we've ran microseismic jobs on our Castle Peak jobs or Uteland Butte jobs and Wasatch jobs, and they all end up being fairly similar, and the numbers shown here are averages.
Okay. As far as the frac hits you mentioned, was there any particular formation or horizon that was more likely to generate a frac hit than another?
It was sort of a mixed bag, and the ones that we've done so far have been Castle Peak horizontals through vertical fields. Those verticals that were offsetting were commingled in the Green River and I think parts of the upper Wasatch. There was nothing that stood out in particular as one zone, contributing to the largest frac hits or anything like that. It was, like I said, it's somewhat of a mixed bag.
So you're comfortable with the setbacks that you're proposing here based off of that?
That's correct.
Okay. And one other question on Exhibit P.
There we go.
So you've lined out a couple different scenarios, but one constant here is you're setting your intermediate string at least to the setback. Is that always going to be the case? Or is there another scenario where you would maybe drill your deeper surface casing and drill all the way to TD?
Yeah, we've thought about monobore options and different ideas like that that wouldn't represent one of these. Generally, we've not gone that method, as we think this is the safest and best way to do it. I can't speak to what we may do in the future, but I can say with confidence that it's not something we're looking at changing in the near future.
Okay. Thank you.
Before you go to Mr. Rogers, can I ask a question about monopore? Is that what's the technique that's being used down in the Permian?
No, I believe they use a similar casing string design like this with surface intermediate and liner. I can't say for sure in all zones. I know as you move deeper into the Permian, they are using a 3-string design. Not being a Permian operator, I'm not sure, but this is something that is used, I think, in the Niobrara, a monobore operation. And it generally has to do with wellbore stability and pressures.
And would you define for the board what a monopore is that we're not using here?
Sure. So these diagrams here represent different casing strings. So as you drill through certain formations, you may want to kind of set them aside or not let them contribute to your drilling program. So as an example, if you're drilling through a salt formation halfway through your lateral that may make your wellbore unstable, it may collapse, or it may take on drilling fluids, that's something you'd want to cover up with casing string, both for safety issues, but also so that you're not losing drilling mud and not having your wellbore contribute fluids to another formation that you didn't intend to. So in a case like the Uinta, we often find that there are a lot of thief zones while drilling, but also the geology is complex enough and changes enough to where you'd want a 3-string design like this.
Point out the 3 strings for the board so that
Sure. So if
you've got the surface.
You've got your, if you're looking at the left-hand side.
Let's use the pointer if we can. So
if you move up towards the wellhead on the left-hand side, that first string right there where the mouse is hovering over, that right there represents the bottom of your surface string. So that's your first string, and as you drill through, you'll continue to drill down to your kickoff point, moving down to where the curve bends there. Once you hit your kickoff point and you kind of turn the wellbore laterally, you'll cement that section as your intermediate casing. And then as you drill your lateral, you'll leave that open while you're drilling it, and when you're done, you'll cement in your liner in that case. So those are your 3 casing strings depicted there.
and then also, how do you, on the open hole swell packers, how do you actually insert those or apply those? Is that done in one trip, or do you have to do that multiple in and outs?
Yeah, so a lot of the open hole swell packers that I'm familiar with, that I've seen, the open hole swell packers is being kind of trialed by Newfield right now. Generally, Crescent Point doesn't go with this option. It has been used significantly in the beginning of the Bakken. And generally what it is, it's a string, one giant piece of pipe that goes down with sliding sleeves. And generally use a ball to initiate those sleeves or to start each stage. So you're not setting individual plugs as you go or individual swell packers. You're using kind of a sliding sleeve system to do that. There's a lot of ways to complete a wellbore, and these are just a couple of them.
Thank you. Back to the division. Mr. Rogers? Or Mr. Doucette?
Dane Doucette with the division. I just have one question. If you could go to exhibit, Mike. And I realize this won't make much difference, but on your EUR calculation, I notice you're using a final rate of 2 barrels a day. And I'm just wondering, are these horizontals still considered economic at 2 barrels a day?
I would say generally no. This is a technical EUR, so the way we look at EURs is there's an economic EUR, something you would report to an investor as a economic reserve, and that's cut off using as soon as it becomes uneconomic, your EUR would decrease or change at that point. The reason we use 2 barrels a day is just generally at that point you're not really contributing much to your overall EUR. If you think about it, you're doing 2 barrels a day for years and years and years, and it may not add up to a whole lot. Generally, a lot of your EUR is in the front end, but that 2 barrels a day is just a cutoff for our own sake. Other people may use different ones. And then I think one other thing to note is these reserves run out for 50 years, sort of via SEC guidelines. And I would say that this well probably meets that 50 years above 2 barrels before you hit that cutoff. So it is well by well, but Crescent Point generally employs a 2 barrel a day cutoff for our technical EUR calculations.
Okay, thanks.
John Rogers with the board. With the division. Other operators have come before this board and asked for 30 and 40 horizontals per 1280. You're being much more conservative here. Is it a lack of understanding of the geology, uncertainty, or is it something you just want to start on the conservative side?
Yeah, it's twofold really, and I would say the first and foremost is probably being on the conservative side. Crescent Point doesn't plan on going and drilling. I don't think any of us have the confidence to go and drill 36 all at once. We don't plan to develop that way. We generally have planned to develop on a much more conservative basis. It's, a one-off well to understand geology, drill through section, understand your spacing, understand your density, and then infill accordingly. We've set ourselves up in this order to, give ourselves 4 wells per section in 3 different benches, to trial 3 different benches at 4 wells a section, which I would say is conservative. If we found out via some of these tests that we needed to go denser, or we needed to have more well bores to drill and drain these minerals, we would come back before the board and ask for an amendment or something else to get that job done. I would also say too, our oil in place calculations may differ from other people, and it's it's a little bit of an art and a little bit of a science on how you create oil in place. And generally, Crescent Point has been conservative on oil in place until we can prove that it is there and it is recoverable. So that has a lot to do with why we're asking for 12 wells per section as opposed to 32 or 60 or some other number.
Thank you.
We have no further questions for this witness.
Board members, any questions? Okay, let's go to the division and remind me to come when we come back to you to admit the exhibits. Okay, now we're to the division for your part of this hearing.
I don't think we have anything else to add. The division supports the request as submitted.
Then we're back to you, Mr. Chicken, for admission of exhibits. I have A, B, replacement C, and then D through R.
That is correct, and I would move that all of those exhibits be admitted to the record.
Division?
No objection.
Board members? They are so admitted. And then we're back to you, Mr. Chicken, for summation.
I'm not going to, this being the last matter and the board having a long day already and me needing to catch a plane, I'm not going to go into much more detail. I think the board is fairly well apprised of this style of request from Crescent Point, and this is just a continuation of their belief in the overlapping spacing scheme, the correlative rights protection that it affords, and the flexibility that allows them to both minimize waste and maximize resource recovery. And we would respectfully request that based on that and today's evidence and exhibits submitted, that the board approve Crescent Point's request for agency action in cause number 139-154.
We're to the board. Would you like to deliberate this, or do you feel that a motion is in order?
Mr. Chairman, I move that we approve this petition as written.
Before we do that, just a comment. This is still part of the pilot project, right?
Yes, this will have an order that is subject to both annual reporting and a 5-year sunset, subject to us, Crescent Point, coming back and asking for this order to be made permanent. So it is still it doesn't say pilot anywhere in that RAA, but it is technically a pilot program based on the board's practice and procedure over the past 2 years.
I would like to see, this is one of the first ones we've seen where you're mixing the vertical and the horizontal, and particularly on the 1280s that have different owners, I'm assuming, in those 1280s. And I would like to see any data that you come up with that shows whether or not those horizontals are interfering with the verticals, and if they're positive or negative or a wash, Would really like to see that data in a year.
Absolutely, Chair, Ms. Davis. And on top of that, sorry, for your former position, in any event, absolutely. And I would submit that I think our annual reporting requirements, and I'm sure the division could back up, are probably the most strenuous annual reporting requirements we've asked for. It doesn't just say, tell us what you want. It is super specific. And I can make sure that in this order that one of the line items is vertical, horizontal well interference issues, so that it's a specifically stated item for the annual reports.
With that understanding, I'm willing to second Carl's motion.
Okay. Any discussion of the motion? The motion before you is to approve the request for agency action as submitted. All in favor, say aye.
Aye.
Any opposed? Let the record show that that is unanimous. And with that, a motion to adjourn is in order.
So moved.
It's non-debatable. All in favor, say aye.
Aye. Run for that plane.
I am about to. Thank you very much, Commissioners.
Thank you very much for the presentation. We appreciate your all being here and for where you're headed and where these new numbers. And with that, we're off the record.
Yes, please do.